The purpose of today's conference is to put together a number of experts in competition law and competition economics to discuss sanctions. I think sanctions are essential to any body of law. If you don't have sanctions, you don't have law. You need to deter. Otherwise, people would not accept the rules or would not comply with the rules. Now, the question, of course, is which kind of sanctions? And there is a variety of experiences. In some countries, you have criminal sanctions, individual sanctions. In other countries or in other jurisdictions like the EU, you have only administrative fines. And increasingly, people question whether, for instance, administrative fines are the right way to go, because it is not clear that they work. And so this conference is about thinking about what are the right set of sanctions. Should we keep the existing system in the European Union, or should we try something else? We will discuss also a variety of things throughout the day. We will talk about, for example, what is the right set of sanctions? That's the first panel. Then we will talk about a number of issues that are critical. They're not directly related to sanctions, but they're sort of neighboring issues, such as, for example, parental liability, compliance programs. And then we will discuss private enforcement versus public enforcement, and enforcement at the national level versus enforcement at the EU level. The EU regime has evolved quite a bit over time, and initially, maybe for the first 20 or 30 years, sanctions were tough, but not very tough. So you had fines, but they were not very spectacular. If you think about the last 15 years, sanctions have increased dramatically. In other words, fines have really skyrocketed to levels sometimes over €1 billion. And of course, it has certainly some deterrence effect, but still, although you have these very big fines, you still see a lot of cartels, you still see a lot of infringements. So you would be tempted of thinking, well, does it work? My personal view is that individual sanctions would be more effective, because certainly some people would think twice before engaging in infringements if they could be held personally liable. So, of course, I realize that this is not the sort of change that you could make overnight, but I think that in the long run, it would be definitely preferable, after some form of reform, to move towards a combination of sanctions to undertakings, but also sanctions to individuals. I think one of the strengths of this conference is that we have people from academia, but we have also practicing lawyers, we have also government officials, and importantly, we have people from industry. One of the problems you see in conferences is that it's very often lawyers talking to lawyers, or lawyers talking to officials. In this case, we've tried to involve some academics, because I think it's important to have the academic view, but also we've tried to involve a number of people from industry, because they certainly have interesting things to say. Also, the speakers come from different jurisdictions. We have, for instance, 3 people coming from the US, because there the sanction system is very different from here. We have people coming from the different member states. So it's a sort of fairly broad and wide set of speakers. I think the natural result of all this is that people will just think about possible reforms. Maybe the conclusion will be that there's no reform needed, but I suspect that there is some reform needed, and I hope it will be one step in the right direction.